Good afternoon. We are commencing again our fourth International Forum on Environmental Justice. And because of the pandemic worldwide, we are hosting it virtually. Remember that you can use the chat that we have created to pose your questions to each of the panelists. The moderator of each panel will compile the questions and then present them to the speakers during the Q&A session. We are broadcasting in both English and Spanish, and on the website you can choose the channel that you want, as well as on Zoom. We will now turn to our third panel on Indigenous people, and we will have with us Linda Smith from the University of Waikato in Hamilton, New Zealand, Manuel Núñez Poblete, Professor of International Public and Constitutional Law of the Department of Public Law of the Catholic University of Valparaíso in Chile. We also have Nancy Fuenzalida, Professor Director of the Center for Human Rights of the University of Chile, as well as Francisco Cali, Special Rapporteur for the United Nations on the right of Indigenous peoples. Our moderator will be the justice from the second room of the Tribunal, Constitutional Court, rather, of Chile. Good afternoon, ladies and gentlemen. Let me welcome you to this third panel on this fourth forum on environmental justice. As we all know, about a decade ago in Chile, since Convention 19 took force, the topic of the participation of Indigenous peoples has taken greater force in different decision-making levels, not just through consultations pursuant to ILO 69, but also in terms of their rights and responsibilities, as well as the sharing of their cosmovision in different spheres, including the judiciary. In fact, we have a very recent ruling, a judgment handed down yesterday. There was a writ of cassation that was filed by a representative of an Indigenous community, and I don't know what our presenters will be commenting on, but certainly that is a topic for discussion, and the Special Rapporteur and our special international guests can talk about the status of Indigenous peoples in decision-making processes and the role of the judiciary. Once again, let me remind our participants that we do have a chat available. Each of our presenters has 20 minutes to the T. We'll remind you when there are 5 minutes remaining in your presentation. And with that, I will wrap up this introduction and turn the floor over to our moderator. Thank you.
Bien. ¿Se me puede escuchar?
Very well.
Sí. Sí, gracias. Bueno, en primer lugar, yo quisiera...
Well, first of all, I would like to thank the organizers, the Environmental Court, the Constitutional Court, and the organizers for sharing this opportunity to address the topic of Indigenous peoples and the defense specifically of the rights of Indigenous peoples in environmental fora. I am not going to seek to review exhaustively all of the existing case law in the 3 environmental courts in Chile, but rather I would like to address the topic of the Indigenous rights in a broader vision in terms of the safeguarding of rights and filings to protect those rights, as well as the common ground that different jurisdictions face in dealing with these cases, as well as some of the issues and problems that have been resolved in, I would say, the latest phase or process of the implementation of our environmental courts since the law was passed. In that context, I'd like to set a few forward-thinking questions as well about some of the roles that environmental justice can play and is playing. Environmental justice falls within a fairly complex puzzle of different jurisdictions. Environmental peoples specifically have these challenges. I hope that you are able to see the screen that I'm sharing at this time. It appears that you can, but I've put several pieces in this puzzle here that we're trying to all have fit together: administrative justice, civil courts, criminal justice, constitutional justice, electoral justice, environmental, family law, labor law. And this is where petitions tend to be filed for protection, recognition of rights, either by the community or by the individuals that belong to these indigenous peoples. Now, we have in Chile a unique institution, which is the Office of the Comptroller General. That's what I'm referring to by quote unquote administrative justice. Indigenous people often turn to these courts with topics that are often associated with environmental issues. And this has been both streamlined on the one hand and made more complex on the other in terms of where environmental cases fall since the specialized environmental courts were created. We understand, of course, that the environmental courts have a certain demarcation of their jurisdiction, but then we also have the role of the other political institutions, and that is what we might call the so-called political justice. And that's the largest piece of this puzzle that is not fitting in, as I put it, as you can see on screen. These overarching global state policies are the ones that in Chile have been the lowest level performers within the configuration of institutions. So unlike constitutional justice, civil justice, and so forth, we end up seeing conflicts emanating out of the what we might call political justice and into these other courts because they remain unresolved at the political or policy level. There is, in that regard, let me be straightforward in saying that we, in general, do not have strong recognition of our indigenous peoples in Chile. We very recently, in the context of the constitutional reform that is just, we're beginning to negotiate and undertake for the first time in this process of selecting the electors or to the vote, the members of the Constitutional Assembly that will create the new constitution. For the very first time ever in Chile's history, we've set aside a number of spots for indigenous peoples. This is a major step forward and it's historic in that regard. But as a general rule, we've seen that there are real limitations and a hampering of the exercise of rights in areas such as property rights, natural resources. It's been extraordinarily difficult for Indigenous people to exercise those rights and get their reivindications in an organized fashion because there's been no policy or political justice, and the cases tend to flow into the other institutions within the puzzle. If we look at the relationship then between the state and the indigenous peoples and the way that we can channel the exercise of rights, for example, ILO 169, in that context, again, no court, therefore, can operate outside the existence of this lack of a political recognition and policy-based justice, or the lack of institutions for governance dealing with indigenous peoples and indigenous rights. So this is something that's in the background at all times. The other thing that doesn't really fit here at all is indigenous peoples' justice, or the capability of indigenous peoples to, on their own, organize and resolve their own conflict. So therefore, for example, when we're dealing with environmental issues, either the environmental agency or the courts end up dealing with conflicts between different indigenous communities because they're unable to resolve the conflict within their own system. And this includes, of course, the issues associated with natural resources. And that means that we end up with conflicts between and among indigenous peoples that end up in the regular courts of law because the indigenous peoples themselves are ill-equipped to resolve them, again, between and among themselves. So if we look at the institutions involved, we can see that there are shortcomings at all levels. Now, my approach to this is that the role of environmental courts, as I'll show you in just a moment, has evolved. It has become, the discussion and debate has been become more sophisticated in judicial terms, but yet it does not make up for all of these other institutional shortcomings, nor should we expect it to, nor would it be good for it to do so. But the biggest player, perhaps, that is missing from this configuration is the state itself, that does not often perceive the environmental courts as true courts of law. If you look at the way the state behaves in interacting with the courts, they do so in ways that when there's a negative impact on a specific community. If you look at the list of cases for environmental liability, the state tends to be, in this configuration, the entity that is suing for reparations rather than the other way around. It's not the people suing the state, but the government filing suit against companies, whether it is many of our major corporations, the National Copper Company, Codelco, the railroad, which is state-owned, and so forth. And so we have to understand that an overarching system of environmental justice would involve opportunities for the state to appear as a defendant, which again occurs very rarely. And in that sense, we should be able to file suit against the government, against the state, for failing to ensure respect for environmental rights. And of course, Linda can explain how that works in New Zealand. And there are other places, other institutions where we have been able to create greater political justice by making the political system liable for the state's actions. Now, what are then the shared or common problems across the board for all of these courts and judicial institutions? One thing that is certainly common in terms of human rights and indigenous peoples' rights specifically is access to justice. This is in part because the communities are unable to access the services of qualified attorneys to file, but also the second is a lack of active recognition of legitimacy that comes through a collective acknowledgement of these rights. I think the primary issue, for example, the writ of Chile's economic habeas corpus, is that this is a writ that can only be filed by individuals, not by a group or by a community, for example. So there are issues with regard to collective legitimacy in terms of the judicial system per se. Another aspect that is important, that is a common problem against all of these jurisdictional institutions, is cultural. There is a cultural barrier that is hard for us as lawyers who've been formed in and trained in a traditional understanding because of the differences between individuals who belong to an indigenous community and those that do not. And this is a second barrier that we need to overcome, particularly when the cases involve parties on both sides, indigenous and non. A third common problem is reaching common ground and understanding on the international standards, particularly ILO 169, and the collective nature and agency of these groups, not just a question of legitimacy, but also reparations that may be appropriate through the administration of justice when justice looks at the group rather than at the individual. You have 5 minutes, Manuel. Which brings me to the core component of this presentation, which is environmental justice. We've had 3 phases, as I mentioned previously. Prior to the adoption of ILO 169, Convention 169, we saw back in the 1980s, there was one of the most emblematic judgments in the writ of economic protection for indigenous peoples was a case in Arica, which was then ratified by the Supreme Court with regard to Lake Chungara and the use of the waters in a national park, where the court understood that modifications needed to be made to existing law. It is a writ that was filed by an Afro-descendant community. Then after that, we have two clear phases in the appellate court level. Between the first and the second phases, we see this distinction between the consultations pursuant to 169 versus and the role of the regular courts of justice, a phase really started in 2011, where we see a substantive differentiation between indigenous communities and others. And the third phase, which is where I think we are today, which allows for the environmental courts to play a role when there are needs for urgent protection to be extended, and also the extension of the right to consultation that allows for regulated acts, for permits, for exploration permits, for example, in mining, again, seeking to overcome the gaps and shortcomings in the performance of our political institutions, and issues associated with governance per se, such as demarcations of borders between indigenous lands and national parks. The environmental courts, therefore, that are specialized in a number of different areas. Now, due to time constraints, I'm not going to delve into this, but the existence of these courts has helped to make the discussion much more sophisticated since 2010, allowing primarily for case law based on these writs of economic protection, or writs of economic habeas corpus. The question, therefore, about extending these protections to other areas of other types of rights and of ensuring compliance has led to a number of judgments that have been hotly debated. We have a number of anthropological reports as well. There's been consistent case law in terms of the importance of improving those expert reports and amicus briefs, as well as the citizen participation, as well as indigenous consultations. Yesterday, we heard that the Supreme Court had handed down a judgment usurping, I would say, to a certain extent, the role of the Environmental Court. The Environmental Court had agreed to hear partially a case, and therefore the Supreme Court has picked up the rest of the case from a filing by an indigenous community. And they filed, I would say, perhaps from an excessively legalistic perspective in terms of Article 17 of the Constitution. They had, there was this interpretation to set the indigenous peoples aside. This is the second time that the Supreme Court comes back with a pro-community, pro-indigenous community ruling in terms of the numbers 6 and 8 specifically of Article 17 of the Constitution. So the important aspect here has to do including yesterday's judgment, it reflects this lack of an overarching approach to Indigenous people's participation in the courts. And on this note, I will in fact wrap up saying that we see a number of conflicts again that exist between, again, and among the communities. My very final thought here is Quo Vadis, where are we headed as we get greater sophistication, greater understanding in the courts? The courts have served as veritable institutions of conciliation. And I can say this, and speaking personally, I was working with an Indigenous community that, for reasons that I won't get into, had never been heard in an environmental case. And in fact, the first time that they felt that they were being heard was in a case before the first environmental court, and that then led to changes to a power plant project. But what I mean is that very often the courts will resolve issues that stem from deficiencies in the administrative area or other courts. Another aspect that we can expect is that the courts, the environmental courts, will help to regulate contracts or agreements in environmental terms. If there are agreements signed between the administrative entities, environmental institutions, and so forth, if they can, the court could also serve to oversee these agreements. And again, I guess I'm just posing this more as a question. Could this happen? I can envision it occurring in terms of governance that goes beyond this. The court could also serve as a court for damages, not restorative, but compensatory, which is inherent to Law 19,300. But I think we could also interpret the range of legislation and the framework law on the environment within this context. And lastly, these courts certainly can allow for greater stakeholder participation. And we see this in yesterday's Supreme Court ruling in terms of the role of the environmental courts to oversee the stakeholder interest and ensure active participation. Again, I will conclude on that note. I just wanted to give you an overarching view and very general vision to open up the conversation, and I look forward to your questions. Thank you very much.
Muchas gracias, Profesor Núñez, por su visión respecto al rol que ha ido desarrollando.
Thank you, Professor Núñez, for your view on the limitations that we have as jurisdictional bodies, and we've been able to delve into these matters, and also with respect to how the indigenous peoples can act in courts of law with respect to their collective rights claims. Thank you very much. I'd like to offer the floor then to our next speaker, Linda.
Profesora de Educación Indígena en la Universidad de Waikato en Hamilton, Nueva Zelanda.
Tuhiwai Smith from New Zealand. She's a professor of Indigenous education at the University of Waikato in Hamilton. She is a writer a very influential guest. And she is also a member of the Royal Society, distinguished with the honoris causa in Canada, and we would like to offer you the floor.
Kia ora, good morning, good evening, good afternoon, everyone. Thank you very much for the invitation to participate today, and wonderful to see you all. I hope you're well. I hope you are taking care of yourselves. We live in difficult and challenging times. So I don't have a PowerPoint, but I have three main areas I want to talk about. One is this larger context that coronavirus forced us to confront as humans, but also as unequal humans. Secondly, I'd like to talk about some of the local or New Zealand-based Indigenous efforts in relation to coping with the pandemic, but also trying to take care of our own environments and our own people, which I think illustrates different approaches to justice, to sovereignty, to being self-determining as a people. And then thirdly, think about the challenges in the future going forward from now. So just if I start with this big context, I think before the pandemic, we would have described some of the big contextual issues as, you know, around climate change, mass extinction, the diminishment of our biodiversity, the challenges of attaining the rights that Indigenous peoples have gained internationally, but also nationally. And in the Indigenous world, I think the challenges of revitalising our knowledge, revitalising our language, and becoming more self-determining as peoples within nation states that have really are formed out of imperialism and colonialism. I think that's how the literature would have generally sort of framed the big issues from an Indigenous perspective. What the pandemic has done, the coronavirus pandemic, in a way has blown open some of these areas, and I think brought us to a point where it is almost overwhelming what humans are having to grapple with. Human societies are barely able to grapple with this pandemic. Advanced countries are struggling to bring it under control. And there's been an interesting debate around science, the value of science, and this kind of sense of people having individual rights to be selfish individuals. And I think for me in New Zealand and others around the world who watch CNN television, we see some of this sort of tragedy unfolding daily on our screens that is questioning our democratic institutions, maybe questioning some of the mythologies that democracies live by. One of those obviously is around equity. Who gets to live and who gets to die? Who gets treatment and who does not get treatment? How is the rationing of the goodies of society, the benefits of society, how is that sort of unfolding in the face of a crisis. Now, from an Indigenous perspective, none of what's happening is a surprise, because in a sense that has been our experience over generations of how nation states have treated Indigenous populations. I think what we are seeing is what we anticipated. And in that is a level of cynicism and distrust of nations, of the nation state, to deliver us life, to deliver us well-being, to deliver us justice. So there is this kind of very present and global context in which I think we have to think about now this intersection of environmental justice, social justice, and from my perspective, what that means for Indigenous peoples. So I want to kind of turn now to maybe some examples from New Zealand of what my tribes have tried to do during this life of dealing with a pandemic, because I think it draws on ideas about what do we do in the face of a crisis? What do we do in the face of a pandemic? What do we as Indigenous peoples, what can we do ourselves? And I think it also kind of points to a different epistemic or philosophical basis on which humans can make decisions that might end up being much more hopeful than the current regimes we're in, and the way both the environment and social justice are regarded. So during the pandemic here, when New Zealand went into lockdown, both my tribes, I come from two different tribal groups, sort of very quickly kicked into action. One of them closed the borders to our tribe, which is on the East Coast. And much to the horror of, people in I guess in the legal area, what our tribal community said is, look, we've been in a pandemic before. The 1918 influenza pandemic had a huge, devastating impact, and we know what that impact was like. We remember what it did to our communities, and we do not want that to happen again. So they initiated sort of a border control. It was helped by the fact that we have a territory that we're the dominant population in, and we have one main road that goes through it from the north-south road. And so it was easy to do. And then what happened, as people started to monitor who was coming and who was going, is they kicked in with another initiative, which was really about controlling or kind of revitalizing food supply. How do you get food to our most vulnerable elders who are living alone when no one could go to the supermarket? And so most of the tribal groups in New Zealand moved very quickly to revitalize kind of quite ancient food supply chains. Young people who were able to move around a little bit more freely were able to collect food and deliver food to elders. Elders were expected to stay home and not move, and there were a number of strategies put in place to ensure that worked. Now those little initiatives were quite inspiring because they demonstrated a number of important things in our world. One is we do have memories of what our people used to do. We have memories of what it takes to survive under really crisis circumstances. And the other one is we have cultural strategies that are still based in the concept of a collective, of living communally, of being able to take care of each other. So even if the world doesn't care about us, or our health system does not care about us, we know that internally we do care about each other in our own communities, and we have systems and strategies and cultural protocols that reinforce that. So that's just one of a number of examples that I can give. But what I want to draw out from these examples are some quite important sort of philosophical or epistemic ideas that I think underpin many Indigenous approaches. It's often talked about in relation to Indigenous knowledge. So one of the foundational principles of Indigenous knowledge, the way it's talked about in the international literature, is this idea of relationality, that humans live in relation, not just to each other. Humans live in relation to the environment. Humans live in relation to the world. But more than that, the environment itself is living. The environment has living entities. And so humans are just one entity that lives in relation to other entities. We live in relation to water. We live in relation to mountains. We live in relation to land. We live in relation to animals and to birds. And that sort of idea is extremely important when it comes to the way Indigenous communities here in Aotearoa, but also now internationally, try and mitigate life when life is challenging in a crisis. How do we exercise reciprocity? How do we exercise care and sustainability when we're living in a time when we don't necessarily know what's going to happen tomorrow? So I think it's important to sort of track that through, because it's one of the reasons in our Waitangi settlement process that many tribes have asked for their mountains to be recognised as having a legal identity, or their rivers are recognised as having a legal identity or personality. And there are examples recently in treaty settlements. For example, one river, the Wanganui River, has been granted a legal personality. And that's because that particular tribe saw that as fundamental to their treaty settlement, more fundamental than any other financial compensation they might get. So this idea about the environment and about our responsibility as humans, our living in relation with the environment, is incredibly important to the way we see our future, to the way we survive, to the way we see our identity. And I think that brings us often into conflict and confrontations with systems of power who see the environment generally as something that humans can exploit until there's nothing left to exploit. I mean, I think it's interesting I read an article recently how there's now so much human junk in space that, you know, people are calling for the regulation of space. You know, why would humans go and then just take their rubbish and send it up into space, or leave their rubbish in space? I mean, to me, that reflects this kind of continuing attitude towards the environments as places that humans can exploit and then leave their human waste in it. And I think it's time for a different paradigm, not just about regulations and laws, but a different paradigm or different knowledge approach to the way we think about humans and nature. So I want to turn now to, sorry, Daniela, 5 minutes yet.
Yeah,
I want to turn now to my third point, which is, so what does this mean going forward? What are the challenges going forward? And I will sort of keep to the sort of general ideas about, I think, the crisis that we're currently in and what we can learn from Indigenous knowledge about how to manage this crisis and how to, in a sense, move forward without doing more harm to the world we live in and to each other and to not just other humans, but the entities of our environment. You know, and I will go back to my first point that it is almost overwhelming what we're having to confront, not just in terms of a pandemic, but in terms of climate change, in terms of mass extinction, all of which is related, obviously, to, in a sense, to the significant changes to planet Earth, the climate of planet Earth. And I think for Indigenous communities in New Zealand, I think what we've learned through the pandemic reservoir or reserve of resiliency, of ability to survive in crises. And that has given our communities a great deal of optimism and hope and being forward thinking about how we can build on that from what we've learned. And so some simple strategies, for example, in one of my tribes that we're trying to work towards is to really strengthen our food supply chain and to rethink our food sovereignty in relation to what we've experienced in the pandemic. So one of my tribes is in an area called the Bay of Plenty. It was named by Captain Cook, the Bay of Plenty, because it was seen as very verdant. It's a growing, vegetable growing community. All my family grow vegetables, are gardeners. And so we can grow food. All right, we can grow food. We know that we can grow, gather and hunt all the food we need. But we quickly turned to buying our food at the supermarket, and we stopped, in a sense, relying on our own knowledge systems for providing our own food. And so what we're doing in our tribe is regenerating not only our food growing traditions and our food growing knowledge, but how to better distribute and allocate food in a more equitable way. And that is a concept of food sovereignty, of being self-determining around food. And it's a really simple strategy that to me illustrates what we can do ourselves. The second one, and I'll point to my second tribe that I come from, which is on the east coast of the North Island, and is basically the only tribe at present who has won rights over our foreshore and our seabed. And those are, all our local communities are now meeting regularly to plan and become guardians of our what's called the foreshore and the seabed, our beaches, our sort of territorial waters out towards traditional fishing grounds, and being much more proactive, not just in taking care in terms of monitoring and watching what happens, but being more proactive about being technologically advanced, for example, thinking about innovation in inshore fisheries, and being much more entrepreneurial, but inside this philosophy of relationality. So I think Aotearoa provides a good example of, you know, Indigenous communities believing we're sovereign and acting as if we're sovereign, and being able to develop really positive initiatives where we confront the systems of power. There are mechanisms in New Zealand to be able to contest those. We often lose in the courts, but we also win in the courts. And, you know, that's strategies that I think we've persisted in and not allowed ourselves to be defeated by. And so I guess my message today is, if Indigenous communities are able to exercise and have the confidence to exercise many of our practices, our philosophies and our relationships, then I think we can start to demonstrate different ways of thinking about the environment and of providing different models for humans to live in a better relationship with the environment. So I'll end it there. Thank you.
Muchas gracias, Linda. Muchas gracias.
Thank you, Linda. Thank you for your view on how this decolonization process has been revitalized with the pandemic and with the climate crisis, and how these strategies are so important and become an example for the rest of the society and cultures in confronting those challenges, and how they have become a voice in the rights of nature. So given the time frame, we would like to thank you and would like to offer the floor to Professor Nancy Yáñez with her presentation. Thank you. Thank you. Thank you very much, Daniela. And thank you to all of the honorable judges of the Environmental Court and those participating in those areas. Thank you for the invitation. Today, I would like to specifically share the development of the rights of Indigenous people to an environment that is clean, sustainable for the Indigenous people in international law. I don't know if you can help me maybe with the presentation. Can you share the presentation? Otherwise, I have one that is just for support, but I am right now using my phone, so I do not know how to share with the phone. I belong to a different generation. Only if it is possible, otherwise I will just move forward. Go ahead and I will try to share the screen. Okay, great. So the idea is to try to express which are the standards of the rights of indigenous people in environmental issues at international level so that we can discuss internally the right to the environment. And my proposal is to really be serious when talking about indigenous rights and to do it when we consider the obligation imposed by Article 1908 in the Constitution and Article 1 of the 19,300 law that express that if the acknowledgement of the environment is a fundamental basis that is establishing the structure of the environmental protection system in our legal organization, including the environmental impact systems. And it is this right that has specific standards when talking about the indigenous people rights. Now, according to the ruling yesterday of the Supreme Court, we again have a debate or discussion in terms of the incorporation of international treaties in human rights when considering the compliance of our country of the international obligations and specifically of the guarantees that are established in our own legal organization in the Constitution and the sectorial laws. A preliminary point that I would like to consider is that I have considered to work from the guarantee perspective, because what is being discussed is the right to the environment of the indigenous people and how this is providing a guarantee through the courts, specifically the environmental courts, and also to not consider the discussion that is generated in the framework of the administrative issue that is considering this impact, and it is not considering this discussion as it is basically interpreting the legal, it is a legal interpretation of this standard that is not considering the activities that are corresponding to them, specifically the environmental courts when providing a guarantee to the right of the environment as an important axis of the system. Having said this, I would like to express that evidently the indigenous rights for the environment are all regulated in different international tools, especially in the specialized ones as the Agreement 169 in many of the different regulations, but specifically Article 4.1 and 7.4. It is also existing in the Universal Declaration of the Indigenous People of the United Nations and the American Declaration, where there is an acknowledgement of the right to the indigenous environment in Article 18, as well as in the Convention to Protection of Biodiversity, Article 8J. But as well, there have been a use of the general tools as a source of production of these laws in acknowledging the rights of the indigenous people to the environment. And this has been, and it has been so, determined by the case laws of the ones that are being active in these areas in the different articles, and the Economic, Social, and Cultural Pact, the Article 1, 2, that is similar to the previous one, but also 11 and 12, the American Convention of Human Rights, Article 27, and the additional protocol of the Convention for Economic, Social, and Cultural, and Article 11. So this regulatory framework means that there is an acknowledgement or recognition of three areas of protection: protection of the environment, protection of the right of indigenous people to establish their own models of development, and the rights that indigenous peoples that have for subsistence according to their own cultural patterns, and protection in equal terms of their economic, social, and cultural rights, which of course means recognition of the different specificities of the indigenous cultures that I will be mentioning. Now, with regard to the environmental rights, but specifically the activities related to development activities, the guidelines offered by international law are determining the obligation of a environmental management tool. And this is a first discussion that is very good for the environmental justice in Chile. The international law has the need or presents a need to have a tool that will assess all of the impacts in these areas of the indigenous people, but establishes one, the need that these environmental impact studies should have a very high standard, and two, that it will be really reflecting the dialogue or the perspective of indigenous people, especially as it was expressed by Professor Smith in her presentation, the different epistemology that the indigenous people have with regard to the environment and the nature as well, that it is seen in their cosmovision with regard to the environment. And this is why the international tools or instruments are saying that they have to be executed in cooperation with the indigenous people. And this is a minimum standard. And of course, we have in our regulation a problem. We're talking about the environmental impact studies that establish clear symmetry when solving socio-environmental conflicts in indigenous territories. The environmental impact study that has been carried out by the owner of the project, the indigenous people, do not necessarily have the tools to carry out or fully understand these tools and to present observations so as to safeguard and prevent impacts, undesired impacts, and not even less to try to incorporate their own perspective from the epistemological point of view into these observations. So the system provides barriers of active legitimacy as it reduces the possibility to participate in environmental justice through a very strict regulatory regime that is imposed, and it is considering restricted complaints, the way the observations were presented in the participation process, or the indigenous consultation. The indigenous consultation is really restricted to a legality complaint, and on the other hand, this clearly has barriers as it offers only one perspective of the knowledge when evaluating these impacts or assessing them. Something else that is also very important, and I am on slide number 4. If you can go to slide number 4, please. And this is related to those regulations that are preventing the integrity of the indigenous activities by preventing the elimination of harmful substances in the environment. It's the next one, please. Storing and elimination of harmful substances. This is an element that is very important. It is a hypothesis where international law expresses that there is an issue that is committing the participation of the indigenous people and prohibits this activity. It is only possible to store dangerous substances in the indigenous territories when there is a previous consent. And we have an important element as international law has established a higher standard when there are events and when there is a hypothesis of a susceptibility of impact that is quite significant for indigenous territories. And one of these impacts is the one that can imply the storage or elimination of dangerous substances in the territories. I think this point is very important, as our system has been designed so the indigenous people can only allow the previous consultation, not even consent, okay? But when there is susceptibility of limitation of rights, and there's a first element that undoubtedly is quite complex, and we'll be seeing it along the presentation, which is our system considers that there is a hypothesis, the limitation of rights, even though international law is conditioning or establishes the consultation as an obligation if there is a susceptibility of limitation of rights to indigenous rights. If there is significant importance, then it provides the need for previous acceptance. Now, in terms of the protection to establish rights in terms of development, international law understands that the rights of indigenous people, as they are the people to self-determination, it guarantees the control over their territories and natural resources necessary to ensure their existence, and in control of those goods that are basic not only to allow the development of their projects. And I would like to place in the discussion the standard of Agreement 169. Agreement 169 has two hypotheses. One says, if we're discussing about the use, administration, and conservation of natural resources, we are talking about the right of indigenous people to community property and governance based in free determination over the territorial areas, ecosystems, and natural resources, where their development problems are structured, the historical ones as well as the contemporary. But Agreement 169, it has the hypothesis of the state considering the ownership of certain natural resources, and in our legal system is quite problematic, not only because the state has considered the property of some strategic resources such as mining resources and water, but also because there is a mechanism established of privatization of these resources where the state itself is limiting the establishment or the guarantee of different activities, different to productive ones, especially these essential goods such as water, and sacrificing the environmental, social, and cultural aspects. But even in this scenario, what we have to express is that there are measures to preserve these territories. And again, we go back to the need of having environmental impact studies. And again, we have a gap in our legal system, as the legal system has incorporated the Declaration of Environmental Impact as an environmental management tool, which evidently does not comply or has a lower standard in terms of the density of the studies that are identifying the environmental impact, same as the mitigation activities. And any of the conflicts involving indigenous people are showing us that these cases have been submitted as environmental impact assessment, because this would not need an indigenous consultation according to how these standards are being implemented in our legal system. So evidently here we do have an important gap that not only does not agree with the standards, international standards, but it is being limiting their rights when we are in front of certain human rights. It should be favoring something that will be guaranteeing the rights and not a restrictive aspect that is considering a literal interpretation or legal interpretation. So among these measures, there is the compensation to damage, and of course there is a point here in terms of the mechanism, which is what this implies, what this mechanism of participation means in exploitation and how this has been affecting the internal cohesion of the indigenous organizations by considering the vulnerability of the economic possibilities, and on the other hand, how this is really taking away the resources by committing their way of life and their habits. And there are two relevant standards in this area, which is the previous and free and informed consultation, and the consent, which is when we talk about mega projects or significant impact to the indigenous people, as in the case of essential rights such as water. It's the limitation of these rights. We have 5 minutes left. And again, in this system, in our system, we are looking to guarantee, or it is conditioned for the indigenous consultation, is the international law. And it was already expressed something fundamental, which is the right to subsistence in guaranteeing the indemnity or integrity of the ecosystem so that the economies can be developed. And because I have very little time left, I would like to close with the case law of the Inter-American Court of Human Rights, Cajonat in Argentina, that February 6 adopted the right to the environment of indigenous people as an autonomous right when considering Article 26 of the Inter-American Human Rights Convention, including our country, by the way, of being able to fully develop the people and the Charter of the OAS. The content of this right is the protection of nature and its elements, therefore the forest, sea, and rivers as expressed here, and certainly it means the protection of nature and the elements independently if there is a limitation of rights to human beings due to this impact. If there is a limitation to live organisms of nature, to understand that the right to the environment is committed. And the state has the obligation to supervise, to require information, to establish contingency plans. And this is Article 101 of the environmental law that has very strict standards in terms of the contingency plans to mitigate due to environmental damage, to act with due diligence. But finally, the case law is telling us about the importance of the environment in guaranteeing the different ways of life, and specifically fundamental aspects such as food sovereignty, the right to food, but not any type of food, but the right of proper food, the right to water, to participate in cultural life connected to the environment. And here the court has been based in the development of other organizations such as the Social, Cultural, and Economic Committee and Rights of Food, observation number 12 as well as number 15 with regard to rights to water. What is really novel, and it is an invitation now for the organizations to guarantee environmental justice in our country, is that the court has a systematic analysis of all rights and the interdependency among them. It is expressing the interdependency between rights to water, food, and participating in cultural life, which are specifically vulnerable to these limitation of rights. So finally, the standards of environmental impact studies, but specifically the anthropological reports that are considered as enough to discard the significant impact on indigenous people, should be considering this interrelationship. The court is quite explicit in expressing that the rights are protecting the distinctive traits that characterize a social group, without this meaning that there is a denial of the historical and evolutionary character, by acknowledging the contribution of these groups to the definition of the concept of development. Therefore, the rights of indigenous people and their recognition is a change in the paradigm of the notion of development into one that will effectively incorporate not only sustainability of resources to guarantee resilience of nature and the rights of the future generations, but also the links that indigenous people have with nature to guarantee their lifestyle in the different areas, in the economic environment, social environment, but as well in their cultural environment, as well as the spiritual. Thank you very much.
Thank you very much, Nancy, for that very complete presentation on international standards to protect indigenous rights and the more progressive views in international fora. We've seen discussions that are very much focused on the development model, the socioeconomic development model that we have currently in Chile. So thank you very much for your presentation. We'll have Q&A at the end. And at this time, I would like to welcome our special rapporteur. He was here just a moment ago, Francisco Cali. Francisco, are you here?
Lo había visto recién conectado.
I saw him here connected just a moment ago.
Ministra, tal vez pasar a la ronda de preguntas.
Justice, perhaps we could start with Q&A. Very well, while he reconnects.
Entonces, vamos a ir por orden. Para Manuel, una primera pregunta.
My first question for Manuel. To define legitimacy, the court has used certain criteria. Do you think that they are helpful in terms of resolving indigenous people's rights? I don't know whether you want all the questions at once or just one by one. Perhaps you could give me all of them and I can take them all then in order. The second question is, are we looking at procedural aspects or other more substantive aspects in considering the indigenous people's idiosyncrasy in terms of their territory, nature within their areas? And then lastly, what do you think affect the role of indigenous peoples in this specific context? Thank you very much for the questions. I will try to be brief because I think these questions are related. Going from more general terms to more specific terms, when I'm referring to access to justice, I am talking in legal terms, strictly speaking, from an attorney's position. One of the challenges people have is protecting their own rights through the judiciary. There are a number of challenges. First, of course, understanding the procedures and finding a free or cost-friendly legal defense or representation in the areas where they live. Very often, we see people burning out on working on these very complex cases. Participating in doing an environmental impact statement and so forth, that it can be very challenging, and there can be hundreds and thousands of pages in these cases, and very often it is a challenge to cull through all of that. So the first challenge, strictly from the legal professional's perspective, is the debate also whether it's Article 17, letter number 7 or number 8.
Si ha participado en la consulta, tiene necesariamente que hacer uso del 17.8 y no puede hacer
and if you've participated in the consultations, you have to use one, not the other. And again, in keeping with this ruling yesterday, so there are a number of challenges involved. Again, depending on whether the case is single party, multi-party. So understanding legitimization is something that does not exclude communities, or should not exclude communities from litigation, but helps fundamentally, again, to safeguard their rights. Now, turning to the question, if I've understood it correctly, Daniela, the use of courts to, could you actually repeat the question? The idiosyncrasy, the cosmovision of nature for Indigenous peoples. That's a fascinating question, not just internationally, but interculturally as well. This is something that we see at the administrative level, at environmental impact study level, and again, across the board in the court, trying to identify that point of contact to understand that unique vision, the way the UN used to word it, the special vision and perception of their own interests that Indigenous peoples have. There's a question then of quantifying that, of trying to make these criteria dovetail with the strict legal sense. And making that effort is important because excessive legalism suggests that there could be no consultation, and the other side of the spectrum would suggest that all administrative resolutions would have to be consulted. If I may, perhaps as a result of the ILO regulations and those from other international organizations, there's been a belief that consultation is the cornerstone of the process. And we've seen in practice that these are expensive and hard to do. and they always end up in court. And so there has been excessive rigidity in that regard by our institutions in terms of understanding what a consultation is and should be. If we opened up the conversation, we could avoid a lot of litigation. But if you tried to have 15 communities participating, funded 15 advisors, obviously there are certain incentives in the way these processes have been designed that means that the intercultural aspects are either left by the wayside or subject to significant improvement. Environmental justice should be a point that brings together these cosmovisions and allows them to interact. As Linda was saying, the agreements that have pushed Parliament to recognize and give legal standing to certain elements, it seems a little foreign to us to give land such legal standing, for example. But if we did, we could find certain ways to establish relationships for good governance that would be different, and creatively we could find this common ground. Thank you, Manuel, for those responses. We want to avoid problems with connections. Let me now introduce Francisco Cali, UN Special Rapporteur on the Rights of Indigenous Peoples. I can see that he's connected. There he is. Now we can see him and hear him. Good afternoon. I apologize for the colleagues for the issues with connection. I had problems. There were technical issues on my end, and then I automatically dropped off, and it was very hard for me to reconnect. But here I am now with you and ready, and it is a pleasure.
Allow me to introduce you, Francisco Cali. He's the Special Rapporteur for the UN for the Indigenous Peoples, member of the Committee for Elimination of Racial Discrimination, and he works on the rights of Indigenous peoples. He's also the president of the repair of victims in Guatemala, and you have 20 minutes for your presentation. I'll remind you when there's only 5 minutes to go, and then we will have some questions for you and for the other panelists. Thank you. Thank you very much to all. I would first like to thank you for the invitation to participate in this fourth forum of International Forum of Environmental Justice. Today is January 14th. This is the Hochtemech table, and it is the Day of Grandparents in relation to the way in which Indigenous people apply justice. For us, environmental justice must be based on balance and harmonic conviviality with Mother Nature, and around 80% of biological diversity is in indigenous territory. It occupies 22% of the planet's surface, and as a population, it's only 5% of the world population. So I believe that this is truly important both for the sustainable management of all resources as well as in the conservation of the environment and biological diversity, both of which are essential for the survival of mankind and this fight for climate change. Nowadays, Indigenous peoples have shown they are the natural guardians of Mother Nature. I have been reviewing the history of how environmental justice began. And it is with great concern that I saw in a couple of documents that spoke of indigenous rights and environmental affairs. It mentioned that the indigenous people had this protection of the environment in international documents that had several shortcomings, and they even say half rights. And I believe that today there are groups that lead the conservation efforts, and among them are those promoted by countries, environmental organizations, national or international, and indigenous people. These systems have their own ways, their own governance and institutions and indicators, which are sometimes supplementary and sometimes antagonistic. So, as we all know, indigenous justice, inclusion, equity, and the recognition of, or the acknowledgement of how the environment is used, managed, how it's distributed, recognized, and participation in this context. We also have questions on Mother Nature based on the principles of balance and harmony. And there's many visions in this regard. The indigenous movement is not very unified in this regard, but we can talk about consensus and silent consensus on the protection of Mother Nature's rights. Until now, the indigenous people are being thrown out of their territories, even within the pandemic, which is one of the greatest crises of mankind, and where many corporations and states are taking advantage of these states of emergency to throw indigenous people out of their territories without having the protection of local and international courts. And as we see here, these resources are being exploited on behalf of development, in the name of development. And in order to recover economically, there is a need to exploit Mother Nature's resources. But conservation is not seen the same way by corporations as by indigenous people. They continue to violate human rights, labor rights, environmental rights, and there's new policies such as clean energy that affects indigenous rights, like crops. And the freedom of the indigenous people is being questioned because many of the indigenous leaders that protect the environment, leaders are being killed. The right to having a clean, healthy environment today is a crime that can cost the lives of the leaders and defenders of the environment their lives. Many fight for the defense of the environment and of biological biodiversity. It's being criminalized and prosecuted. And we should not allow indigenous people to continue to be expelled from their own land, their own territories, and excluded or discriminated, marginated, politically, socially, and economically speaking. It has been shown that they are the engine of our people and of the environment. There, in many conferences, I've heard that indigenous people, within their population, there's farmers, and these farmers are producing food, sometimes without food safety measures, because the population needs to continue to eat, needs to consume these products that come from the environment. And it would be an act of justice if we saw we talk about all these elements stopping deforestation, avoiding the contamination. It is very important to recognize all these rights of indigenous people. I heard in passing, I heard what our colleagues were presenting before I was able to connect to the conference. And I heard that some of these rights is the right to consultation and to consent. This is one of the fundamental rights for the application of environmental justice. Indigenous people have rights systems that are associated with the environment. Cultural, environmental rights are of the utmost importance for us. And these mega diverse countries are having difficulty in bringing together nature and culture. It is understood as a system of rights. Today we have a record where conservation systems should be based on rights. We need to recognize indigenous people, their justice systems, their own rules, their organization and territorial governance systems. Development, the generation of clean energy, privatization of rivers and the sources of water, all these are not to be taken on behalf of indigenous people. Sometimes you're told that they cannot consume this water anymore because it's been privatized. So indigenous people, we have ILO 69 on indigenous people and the Universal Declaration on the Rights of Indigenous People. When we are truly told that it is a full participation and there are consultations, that will be different. These are challenges that we have for this new year, and we can only achieve them together, understanding and recognizing the contributions of each system. It is important for these to be present in all of the biodiversity fora. New policies, post-2020 policies are being developed, looking towards 2050. The UICN and others are reviewing the category systems for protected areas. And this is where we need to have social and territorial justice that will respect indigenous rights. To conclude, and I don't want to go over my 20 minutes, I would like to mention that it's important to stress that environmental justice addresses ecosystem balance in order to prevent pandemics such as COVID-19. Today, we make a call to rethink our individual actions, collective actions, and global actions. And as my people would say, Maya Tachikel, thank you very much. Thank you, Mr. Rapporteur, for your presentation and for enlightening us on all the issues that indigenous people face and all the tasks we have pending at an international level. Thank you.
We will continue with the questions. I have a question for Professor Linda. As a court, we are, it's a mixed composition. It's based on law, but also scientific. So the indigenous people is central in the elements that are solving these issues. So how do you see it, Professor?
Profesora Linda? Yeah.
Professor Linda? Is it okay with that question? Because the other ones are not related. Do you want me to repeat it?
Can you repeat it in English?
Oh, okay. So we are technical legal court. So the question is how this kind of court can incorporate indigenous knowledge into the decision making.
That's a good question, and obviously it's not an easy one to answer when court systems based on the European juridical concepts often, like other disciplines of knowledge, have very strong boundaries for excluding different ways of knowing, and specifically excluding indigenous knowledge. I think what's been learned in New Zealand and what's happening at the moment is the more we have indigenous legal scholars ourselves, the more hope and possibility there is for influencing the legal system. So one of the things happening in New Zealand right now is the work happening under the sponsorship of Justice Joe Williams to incorporate more Māori knowledge into law. Law, L-O-R-E, and law, L-A-W. And so there is work happening that's got the support of key justice in our system, and a number of lawyers are working to influencing how that happens. I think it is partly educational in the way lawyers are trained, in the way the legal system, that the issues the legal system has to grapple with. And I think our legal system in the treaty settlement process has had to incorporate new concepts and stretch, if you like, concepts that already exist in the law, but maybe have not been extended to the same extent. I think it is also about legislation and about what happens politically.
Okay, thank you very much. And a second question regarding COVID-19. Do you know any case of any sort of gap or contradiction between indigenous protocols and the scientific protocols about the management of this sanitary crisis?
Yes, our funeral protocols had to be compromised, but, we're not stupid people. And as I said, we did remember the experience of the 1918 influenza pandemic. And so our leaders, our tribal leaders, very quickly were able to adapt our cultural protocols to cope with the regulations. There was a point at which there was a big disconnect between what the government was saying and what our own communities felt. but we do have a number of Indigenous doctors, medical doctors, who were able to translate knowledge backwards and forwards to ensure that our people were able to comply and that our people were kept safe. So that's more than consultation. That's really based on deep relationships and on having a government that did try to be inclusive.
Thank you, Linda. One last question. Like I commented before to you of the record, that we are about to start a new discussion about our new constitution. So what do you think that our constitution can take into account to assure a real democratic participation of Indigenous people?
I guess it's how our constitution enshrines intentions. You know, so we don't have a written one document constitution in New Zealand.
Yeah, I know.
Yeah. And,
the different system, yeah.
Different system, but I think a constitution generally is a sort of a document that lays out some fundamental rights that will stand across time, but it also is a document that spells out a vision and the intentions of a society or of a government, of governance. And I think it's how do those intentions become translated into text, into words in the Constitution. I mean, I'm sure there's a fine art to this, because not all good intentions get translated into good implementation, and they can backfire. But we know from Indigenous rights more broadly, firstly, there has to be an acknowledgement of Indigenous peoples, recognition that they have rights, and an inclusion, a real genuine thought in which Indigenous peoples can be included as Indigenous peoples inside the constitutions of complex post-colonial type societies.
Thank you very much, Professor Linda. Ahora preguntas para la profesora Nancy Yáñez.
Now we have more questions for Professor Nancy Yáñez. Which constitutional elements do you think can be incorporated in the in the Constituent Assembly or process? Well, first of all, I think it is fundamental to have a constituent process acknowledging that the Indigenous people are pre-existing to the creation of the Chilean state. Therefore, the Chilean state should consider a condition of being plurinational, that is in a territory that from ancestral times, different Indigenous groups have been living. The acknowledgement of free determination is fundamental, specifically to end colonial practices in the relationship between the state of Chile and the Indigenous people. The Constitution is an opportunity to decolonizing, and I think it is fundamental to here consider that the independence of the Latin American countries did not necessarily mean a decolonization of Indigenous people, and on the contrary, the Indigenous people, or many of these Indigenous people, were incorporated to the Chilean territory during the Republican process and through acts of force, which finally expresses a relationship that has to be settled. Now, one of the fundamental elements of colonization of the states, and specifically, and Chile not being the exception, is the Terra Nullius Declaration of the Indigenous territory, and therefore the appropriation of the state and through them of private sector, that where there is the culture of the Indigenous people, occurring. So to acknowledge or recognize these territories is a fundamental aspect for Indigenous people to be such equally in terms of rights as the rest of the Chilean population. Otherwise, they are in a subordinate condition where this means that we recognize a certain cultural traits, but not the condition of people with a project that can really participate in this new Chile, especially in the concepts of how we will be developing our lifestyle in this territory with the limitations imposed by the current situation of extreme drought, climate change, and an economic model that is considering the unsustainable exploitation of natural resources. Thank you, Nancy. Now, with regard to your criticism about the environmental impact projects that are somehow affecting Indigenous people, and in general terms, when there isn't a significant impact, what would the consent mean coming from the original people or from Indigenous people? Well, I have a response in two senses. First, and considering the observation presented by Manuel previously of this lack of regulation, that everything has to go through a consultation, I believe that the notion of directive limitation of rights provides a certain standard when there is a possibility of have a consultation from the Indigenous people. Should there be a lack of governance due to too much consultation? Of course, this is a reality. Many different peoples in Colombia, for example, this has been a paradigm because there are so many consultations that the Indigenous people are not enough in being able to deal with these processes. So it is also affecting the daily lives of the Indigenous people, which is hard to live with. So one thing is the direct limitation of rights, but the other one is the significant limitation as a hypothesis of the consultation. Now, having clarified this, the consent has the element allowing Indigenous people being able to oppose to certain decisions made by the authority. The consent limits the state to carry out measures if the Indigenous people do not agree. And of course, it is clearly established in the transfer of population agreements. 169 of Article 16 says it very clearly. If, as a consequence of a measure, the population is to be transferred, there is a need of consent of the population, meaning that they cannot be transferred without their consent. And should the imminent transfer due to the protection of lives of the Indigenous people, such as in the case of natural disasters or situations such as those that are not preventable, then in such an event, they have to look for relocation mechanisms and to see the possibility of having them return as soon as possible. The Inter-American case law has different elements. It considers the element of the mega project, meaning the size of the intervention and the limitation of essential goods, as when there are certain elements of the environment that make lifestyle not feasible. Subsistence of Indigenous people are at risk, and in this case, it has considered the consent. And we could then understand that, yes, effectively, this is following a certain logic of the impact of relocation in the habits of the Indigenous people in their lifestyle. The United Nations Committee has done exactly the same in terms of the limitation of rights in waters, as if there is a significant limitation to the rights and the hydrological system of the Indigenous territories that could generate an important limitation of rights to the indigenous lifestyle. For example, in establishing certification processes, undoubtedly we should be talking about consent, and I think this is what we're saying in the Atacama salt plains in Atacama. In this very same line of questions, and if there can be an excessive burden on the state and the indigenous people, do you think there are different tools where environmental impact can incorporate into indigenous impact or perspective in this area? I think there are many different ways to do it. Well, we could right away design the environmental impact study in such a way that there is no responsibility of the one carrying out the project. It could also be thinking that the environmental impact study should be obtaining the information from the owner of the project as well as the indigenous communities. And there should also be a third party, the responsible party, that is subject to accountability process by the different economic and political powers. That funding that this expresses can be easily solved with the obligation of a guarantee that can be presented by the owner of the project so these studies can be funded. The truth is that there is a subsidy from the state as well as the civil society and the communities that have to have their own resources to be able to be participating in a process that is meaning the benefit for private parties. And we can say that there is a higher interest linked to the development of these projects, but we have recently witnessed, especially in where I was involved in a certain activity where the owner of the project in Tiltil is expressing to the court that having obtained the ruling of the environmental court, the project is sold to a transnational company. So we can really think that finally there is a financial speculation involved. So evidently what is interesting here is that the private interests are responding to economic interests and are hegemonic from a certain group. And the environmental impact study as a management tool should be protected of these specific interests, this specific private interest, so as to guarantee general interests as well as other participants, as in this case, the indigenous people's rights. And I believe that another tool that is fundamental here is the planning tools at territorial level and basically the participatory character that they might have. I think we should be considered more participatory democracy where the cost that it can mean to have a robust costs of participation will be meaning benefits as long as there is a development model that is more sustainable or more equitable. And under that idea, a participatory instrument of territorial activity should generate agreements in certain areas of protection over the ways in which there are certain resources regulated. And of course, it means reviewing the regulation regulating the water resources. So in this way, we could have political decision processes prior to that would allow to safeguarding the private initiative as a fundamental element of the environmental interests that are not only for the owners of the projects, but for the people of Chile as a whole.
We have a final question for Francisco Cali. Is the paradigm of economic growth compatible with indigenous people's rights? What should the paradigm be? Well, yes, of course. I mean, if we look about sustainable development is certainly compatible because sustainable development has to be based specifically on the care for the environment, not over exploiting the natural resources that are there, and that from the perspective of indigenous people, of course, are a fundamental part of nature. Often this is not properly understood. There is an anecdote about a Kopi elderly woman who was against the the carbon mining, because coal in this regard was like this is the Earth's liver and you could not remove it. She said this back in the 1970s, and no one really understood what this Kopi woman was saying. These were not scientific knowledge, but empirical knowledge. And what we now call ancestral knowledge, because people are loath to call them traditional indigenous scientific knowledge. Well, the truth is, it was scientific knowledge, indigenous people's scientific knowledge. Coal is an important ore, and it is important to caring for Mother Earth. And therefore, that is why there are no water filters that do not have a little bit of coal to purify that water. And that's just one simple example. I could give you many others to say, yes, sustainable development, not pure development, but sustainable development is absolutely compatible with indigenous people's rights. Thank you very much, Francisco. And then with your response, we will conclude this panel. I would like to reiterate our gratitude, our thanks for the knowledge that you have shared with us. And I would like to invite you to join us tomorrow for the second day of our forum. Magdalena, Cristian, I will give the floor back to you as our hosts. Thank you, Madam Justice, and thank you to all of the speakers who have joined us for this third panel at this fourth International Forum on Environmental Law. On this note, we will conclude, thanking you all for joining us, and we look forward to seeing you tomorrow